Fear and confusion spreading through immigrant communities following a Supreme Court ruling that greenlights the Trump administration's power to quickly deport undocumented immigrants. And that is even to countries where they have no family or any connection at all. To break down what this ruling means and who could be affected, we're joined by immigration attorney Mariam Masumi Daud. Thank you so much for joining us.
Thank you for having me today.
So first of all, what do you think about this ruling? I mean, the basis for allowing people to be sent to another country other than where they're even originally from?
Well, I think what the Supreme Court has done is essentially nullify federal law and our international treaty obligations. The United States is a party to the Convention Against Torture Treaty, which requires us to not send anybody to a third country where they could face imminent torture or persecution. And I think by allowing the administration to go forward with third country removals before the lower courts even decide the legality of the process is something that's going to cause a lot of irreversible harm.
Should this be, as an attorney, I mean, should this be something that is reserved for people with a clear criminal record? Because we're seeing cases of people who are accused of possibly committing a crime, and they're not just being sent to another country, they're being sent to another country, to a prison, to a facility.
Right. So regardless of whether someone has criminal history or not, our laws are very clear that if an administration wants to send someone to a country that they have no ties to, they must follow certain basic steps that are embedded within due process. Usually the requirements are that the government give an individual at least some sort of notice that they will be sent to this country, as well as an opportunity to express a fear of return to that country and demonstrate to a judge that their life is in danger there. And at this point, it really, again, doesn't matter whether someone has criminal history or not. That due process should exist. But what the Supreme Court order does is allow the Trump administration to bypass that process and move forward with removals to countries of their own choosing. And these can be countries that are very dangerous. We've seen removals to Sudan and South Sudan and Libya, countries that the State Department has declared as being very dangerous. So ultimately, due process is required regardless of whether or not someone has arrest history or not.
Well, and speaking of due process and having a chance to present their case, we're looking at some of the video where these ICE raids have taken place. These ICE agents are waiting outside courthouses as people are trying to pursue a legal path to citizenship for their immigration hearings. So how will this play out there? Are we going to see more of this probably?
Well, the tactic of detaining people at immigration court is something that is something I haven't seen. I've been an immigration lawyer for 15 years, and this is a very aggressive tactic. And it will depend on the stage at which a person's case is. If a person has already a final order of removal by an immigration judge, there is a possibility for the government to move forward with a third country removal. If the person is somebody who's subjected to what we call expedited removal, there may be a possibility of third country removal in that scenario. So ultimately, it will depend it'll depend on the procedural posture of the person's case. But it is truly concerning that more and more people are facing the possibility of third country removal without the very basic due process rights that exist within our system.
So for people who are early in the process of their hearing, they don't have that immediate ruling order to be deported. Can people request a virtual hearing so that they don't? A lot of people are very concerned about showing up for all kinds of hearings, much less an immigration hearing. So is there a virtual option?
Certain courts already allow for individuals to appear virtually automatically. Then there are also some courts that don't and would require that a person provide a written motion requesting permission to appear virtually. We as a law firm have submitted such motions, and some judges have granted our requests while some have not. Then the standard that you have to prove is good cause. And unfortunately, some judges have not agreed with the fact that a person cannot proceed with their case in a fundamentally fair way as good cause, and have required clients to still show up to court and potentially face detention.
Before we let you go, just really quick, as an immigration attorney, any advice you can give for people who are listening and concerned?
Absolutely. I think the biggest thing is if you do have a lawyer, stay in touch with your lawyer. Make sure that you are completely up to date on the facts of your particular case and the law and how it applies to you. I also think if you're somebody who has an order of removal or somebody who could be subjected to expedited removal, it's really important to work with your counsel to ensure that you have a way forward if something like third country removal or even detention is a possibility. And ultimately, just staying up to date, following respected and trusted people and authorities on this issue.
All right. Mariam Masumi Daud, immigration attorney at Johnson Masumi Law Firm. Thank you so much for your insight and information. We appreciate it.
Thank you for having me.